Assalamualaikum warahmatullahi wabarakatuh. My name is Fatima Zahra binti Muhammad Ashraf. My matric numbers is 084887. I used to learn in SMKA Naim Bin Banat before entering UNIZA. My motivation to actually enter law school was actually because of a game series called Ace Attorney. I would like to pursue degree of law, probably in UNIZA or UITM. And then lastly, I would like to become a judge.
Assalamualaikum warahmatullahi wabarakatuh. My name is Hana Danisha binti Muhammad Ali Shah. My matrix number is 085360. My previous school was SMK Sri Gading. Why I entered into this diploma law is because I would love to study in law because my mother was a lawyer and I always follow her to work and I got inspiration from her and I want to continue her legacy. I really love to pursuing my degree in law and actually my career interest is I wanted to be a housewife. I really want to take care of my husband and my children. That's all.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Farahistila binti Muhammad Imran Syukur and my matrix number is 085395. My previous school is only in Kuala Terengganu, which is SMA Hariah. And my motivation to enter law school is back at 2023. UNIZA Law Society Club held a school tour and they came to my school. From that tour, I got motivated to enter law school and to pursue the law in Malaysia. And then my plan after I finish my diploma is I want to further my studies in degree and masters. For degree, I think I might continue my studies in UNIZA. And for master, I wish to continue my studies in London. And then my career interest is I want to be a defense lawyer.
Assalamualaikum. My name is Adi Zahra binti Saleh and my matric number is 085679. My previous school in Johor is Sekolah Menengah Atan Nuria. My motivation to enter diploma in law because I want to prove to myself that I can do well in this course. My future plan after diploma is I want to pursue my study in degree in law. My career is interest. I want to be a lawyer. That's all for me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Alex Lira binti Muhammad Asmail. My matric number is 084767. I used to school at Sekolah Menengah Kebahasaan Pencaban. Actually, I don't have any motivation to enter to law school, but I just follow my father's plan. After diploma, I would like to pursue a degree in law. I also interested to work as a lawyer. That's all.
Hi, my name is Muhammad Danish bin Jafri. Matrix number 084951. And my previous school is in Johor, Sekolah Menengah Kebahasaan Agama Bandar Penawar. And one of the main reasons why I want to enter law school is because I enjoy and like it. I found law is very fun in so much way. For my future plan, the diploma, I want to continue my studies maybe in UIA or UM for degree of law. And for career job, I just want to have a job in the field of law. Alright, so for the main advantage of using my lecture notes and slides as my primary studies material for any law subject is because that they are directly aligned with the course syllabus and also for the learning outcome itself. This helped me to focus on the topics that are most relevant on the classes, assignment and also examination. Therefore, I believe that lecture notes and slides are more valuable resource for studies because they are more relevant, reliable, time efficient and closely connected to the requirements of the course.
Hi everyone, my name is Alex Lira binti Muhammad Asmail. Today I'm going to tell you guys why I choose to make tutorial activities in poster. Here first, tutorial activities improve students' understanding of the topics taught in class. Especially when we make it in poster, it will be easier to understand. Second, tutorial activities help students develop critical thinking and problem-solving skills. Here first, tutorial activities improve students' understanding of the topics taught in class. Especially when we make it in poster, it will be easier to understand. Second, tutorial activities help students develop critical thinking and problem-solving skills. Other than that, tutorial activities also encourage active participants and meaningful discussion among students. When we make it in poster, we can see which one the law, which one the conclusion, and moreover.
Hello everyone, this is why I prefer to summarize case in my studying through this semester. So let me tell the advantage of it. Okay, the first one I think it can improve the understanding by presenting the key facts and issues in clear and concise manner. And the second one is we can save time as there is no need to read the entire court judgment. And other than that, we can highlight important legal principles and the court's reasonings. Okay, and the next ones, we can facilitate revision for examinations, assignments, and presentations too. Moreover, we can make case comparison easier by identifying similarities and difference between cases. In addition, we can develop legal analysis skills by showing how the law is applied to the facts. And the last one is we can provide a quick reference for important information and court decisions.
Why I choose these tutorial activities? Because in ways as my study method, because it's helped me organize my notes in a clear and structured way. Because of these methods, it's helped me apply the law to given situation, which improve my understanding of the topic. It also helps me learn from the case example, making the concept easier to me to understand. Lastly, this method makes it easier for me to review before exam and remember important points. That's all from me. Thank you.
Group discussions are highly effective for learning in general because they transform passive studying into active, collaborative problem solving. When you explain your complex ideas out loud to others, it forces you to organize your thoughts and quickly highlights any gaps in your own understanding. Hearing your peers' perspectives exposes you to new angles and interpretations you might have overlooked on your own, while building essential communication skills that apply to almost any career.
One of the ways that we can learn legal concepts in an engaging and fun way is that by playing Kahoot. Through interactive quizzes and friendly competition, students actively participate in lessons rather than just listening to lectures. So Kahoot helps improve knowledge retention by encouraging quick thinking and problem solving and recall of information. It also creates an enjoyable learning environment where students stay motivated and always focused. So as players answer questions and receive instant feedback, they can identify their strengths and areas for improvement.
I live my day as if it was the last.
So, in the case of Hyde versus Wrench, how did the facts of the case actually go? Basically, it started with the defendant offering to sell his farm to the plaintiff for £1,000 sterling. But the plaintiff decided to ask for a lower price. The defendant refused the offer, and the plaintiff later then decided to willingly pay for the original price. However, the defendant had decided to not sell the farm to him.
Right, so for our legal issue, our first issue is that whether Hyde's offer to pay $950 constitute a valid acceptance or a counter-offer. Our second issue is that whether the counter-offer terminates the original offer and preventing it from being accepted later.
Assalamualaikum warahmatullahi wabarakatuh. In height against range, the applicable legal principle is where the mirror image rule and acceptance must be on absolute and unqualified assent to all the terms of the offer, which is the counter-offer. A counter-offer occurs when an offeree introduce new terms or attempts to change the price of the original offer. In common law, a counter-offer rejects and destroys the original offer. The original offer cannot be received unless the offerer makes it again.
Assalamualaikum warahmatullahi wabarakatuh. The court decision for a height against range case, the Court of Chancery dismissed the plaintiff claims. Lord Langdale's ruled that there was no valid binding contract between the parties. When height offered £950 instead of the request £1,000. He made a counter offer. By doing so, he will reject the original offer made by Range, effectively destroying it. Therefore, Hyde could not later choose to accept the original £1,000 offer because it is no longer existed.
The decision in Hyde versus Range is important because it makes things clear and simple in business deals. If someone makes a counter offer, the original offer is no longer valid. This helps the person who made the offer avoid confusion because the other party cannot come back later and accept the old offer after trying to change the price. It also reminds people to think carefully before making a counter offer because they might lose the original deals.
This principle is directly mirrored in the Malaysian legal framework under the Contracts Act in 1950. Section 7A states that in order for a proposal to convert into a promise, the acceptance must be absolute and unqualified. Malaysian courts heavily rely on the principle in the case of Hyde versus Range as a persuasive authority to hold that any modification or counter proposal will reject the original proposal. This was clearly seen in the local case, which is the Malaysian Securities Ltd versus Overseas Chinese Banking Corporation Ltd, reaffirming that a counter-offer kills the original offer.
So, the case started when the Carbolic Smokeball Company created and manufactured a product called Smokeball and advertised in the newspapers that they would pay some £100 as a reward to anyone who still contracted influenza despite already following the instructions properly. The company also stated that they put a lot of amount of money into their company's bank to show their sincerity. However, Mrs. Carlyle, who bought and used the Smokeball, still caught the flu and later then on sued the company. Yet the company refused and argued that the advertisement was just a mere puff and it's not a legally binding contract.
Alright, so for the second case, the legal issue here is that for first, whether a unilateral advertisement directed to the whole world can be accepted as a legally binding offer. Second issue is that whether the plaintiff was required to notify the company of her acceptance before performing such requirement or condition.
Assalamualaikum warahmatullahi wabarakatuh. In Carlin against Carbolic Smokeball, the applicable legal principle is the first one is unilateral offer. An offer made to the world at large which can be accepted by anyone who performs the condition specified in the offer. The second one is dispensation of notice. Generally, acceptance must be communicated. However, in unilateral contracts, the offerer effectively waives the requirement of notification of acceptance. Performance of the condition constitutes acceptance, and the intention to create legal relations. Statements backed by the concrete actions like depositing money show a serious intent to be bound, moving beyond a mere marketing fluff. That's all.
Assalamualaikum warahmatullahi wabarakatuh. In Carlyle against Carbolic Smokeballs, the court of appeal decides that a valid contract exists, and Mrs. Carlyle was entitled to claim the £100. The court ruled that first, an offer can be made to the entire world because a contract with anyone who step forward and fulfill the condition. Second, the £1,000 bank deposit was proof of an explicit intention to create legal relations, not just a marketing gimmick. Third, in unilateral contracts, communicating acceptance prior to performance is not necessary. That's all from me.
This is a landmark case that balances consumer protection with corporate accountability. It rightly stopped business from hiding behind the excuse of sales stock or marketing gimmicks when making public promises. The courts focus on the £1,000 bank deposit show that the law looks at objective evidence of intents rather than subjective hidden motives.
The principles established in Carlyle are integrated to the Contracts Act 1950. Section 8 states that the performance of the condition of a proposal is an acceptance of the proposal. This perfectly codifies the unilateral concepts where no prior notification of acceptance is needed. Malaysian courts frequently apply Carlyle, for instance, in Fraser v. Everett and modern consumer disputes. The courts reference these principles to decide whether promotional advertisements amount to a building unilateral offer or a mere invitation to treat.
So the knowledge that I have gained from this course is that I finally able to grasp and comprehend my understanding on the legal principle, which is basic, but it still can help me in my daily life.
The knowledge I gained from this course is that I can identify the issues, I can identify the law, and I know how to conclude my essay with the best sentence.
Assalamualaikum. From this course, I learned more clearly about what contract law is and how it works. Before this, I knew a little bit about contracts, but now I understand important elements like offer, acceptance, consideration and intention to create a legal relation. I also learn how a contract can be valid or not valid. By studying some cases, I can see how the law is used in real situation, which makes it easier for me to understand.
So, reflection on learning experience in contract law. Throughout this course, in my opinion, I learned the basic principle of contract law and how contracts are formed. I gained knowledge about offer, consideration, and the rights and responsibilities of parties in a contract. This helped me understand how contracts work in my life.
Assalamualaikum warahmatullahi wabarakatuh. So, studying contract law gives me a better understanding of the rules that apply to agreement between individuals and business. I learned a valid contract is great, and the legal efforts when one party fails to fulfill the obligations. Okay, so second, the subject was not always easy for me. Same topics were difficult to understand because they involve legal language and many court cases. However, continuous reading and completing exercise help me overcome these difficulties.
Yeah, Assalamualaikum warahmatullahi wabarakatuh. So what I learned from this course itself is that I learned the important principle, complex legal principle in contract law. For example, about the offer, acceptance, consideration, intention to create a legal relation, and also the capacity to contract itself. And I also familiar with the action that may affect the contract itself. For example, fraud, misrepresentation, and also coercion. And the funny part that is that I know how to apply the section in Contract Act to the problem-based question. That's all.
So the challenges that I have found myself having difficulties with is how to apply the legal principles that I've learned into the application in my essay.
Challenges that I often face is that I find it hard to understand what I learn in class.
And one of the challenge I faced was understanding difficult legal words and case explanation. Sometimes the cases were confusing and hard to follow. I also had difficult answering problem-based question because I was not sure how to apply the law correctly. At first, I felt a little bit lost, but after more practice and explanation, I slowly improved.
I think one challenge that I faced was understanding legal terms and applying legal rules to case studies. At first, some concepts were confusing, but with practice and discussions, I gradually understand them better.
At first, I found it challenging to connect the legal principle with practical situation.
The things that quite hard for me challenges is that how we have to remember a lot of section, a lot of case authorities, and at first using ILAC to apply to the problem-based question is also quite hard for me because ILAC is they have many types of ILAC, depends on the lecture itself. Yes.
So the improvement that I have seen myself going throughout the semester is that I'm able to identify legal issues and apply the applications accordingly.
I know how to identify the issues and then I know how to analyze the things that I need to.
During this course, I improved my legal reasoning skill step by step. I learned how to find the issues, choose the correct law, and explain my answer properly. Now I can organize my answer better compared to before. Even though I still need more practice, I feel more confident when answering legal questions. Contract law is important in daily life because we use it almost every day without realizing it. For example, when we buy things, order food online, or sign agreements, we are actually making contract. Contract law helps protect our rights and makes sure both parties are treated fairly.
Okay, the third one is the course also improved my legal reasoning skills. I learned how to analyze legal issues, identify relevant laws, and apply them to different situations. These skills help me think more critically and logically.
That contract law is relevant to everyday life because people often make agreements without realizing it, whether buying goods, using service, or buy house and lands.
And the skills that I learned is that I can identify the most relevant section, and after identify the cases, I can also apply to the most relevant way to apply to the problem-based question or situation.
So, in my personal opinion, the reason why learning contract law is very important in our daily life is that I think that it helps me from getting scammed and being lied to when buying certain products, especially in online interaction.
Contract law is important because we cannot be fooled by other scammers or those who are trying to lie to us, such as it's either online or physical store.
Other than that, contract law is really important in our everyday life because people enter into agreements regularly, such as buying goods, renting houses, or accepting employment offers. Understanding contract law helps people know their rights and avoid disputes.
Knowledge of contract law helps people make informed decision and avoid misunderstandings.
We know that there are many things in our life that connected directly to the contract itself. For example, about the insurance, you want to do anything, for example. And if we don't know about this contract law, it is like limited our knowledge to connect it to the world.
So, what I have discovered personally is that I find my strength to be able to understand easily some of the legal concepts. However, my personal weaknesses is that I tend to be very clueless and unable to apply the legal applications in complex situations.
My personal strength is I do not know when to give up. But my weakness is I often get sick that often makes me do not have the time to do the things that I need to do or want to do.
My strength is that I will try my best to understand something even it is difficult. I do not easily give up and I'm willing to learn. However, my weakness is that I sometimes have poor time management and I tend to overthink when answering questions, which makes me less confident.
And then my strength is I am willing to learn and understand the concepts of contract law. However, my weaknesses is I really lazy when it comes to study and sometimes procrastinate and leave tasks until the last minute. So I need to change that attitude.
Okay. In addition, one of my strengths is my determination to complete tests and understand the topics taught. On the other hand, I sometimes need more time to understand difficult concepts and improve my confidence when answering legal principle.
My strength about this course is that I really like contract law. It's like it gives me motivation to continue my study in contract law. And if I can state one of my weaknesses that there are so many authorities, care authorities, and also the section for the Contract Act that we need to list out in the examination or in the problem-based question.
So, what I have seen myself to thoroughly improve myself is that I do my own notes and I also consult with like Madam Hanin to assess and look at my practice exercises.
For self-improvement, the first thing I need to do, I think I need to rest well. And then the second thing, I need to have a timetable so that I can manage my time. And the third thing is, I need to appreciate and use my time when I'm healthy, efficiently.
To improve myself, I will try to manage my time better and not do my work last minute. I also plan to practice more questions so I can understand better. Besides that, I will try to simplify notes and cases so it's easier for me to remember and use during exams.
To improve myself, the last one, I plan to manage my time better, review lessons, tutorial regularly, and participate more actively in class discussion. These steps will help me to become better person and better learner in the future. That's all from me.
Moreover, in the future, I hope I become a better student by improving my study habits, reviewing lessons more frequently, and practicing more legal questions. I believe this effort will help me strengthen my understanding of contract and perform better in my studies.
What I can do for my self-improvement is that about the time management. We know that currently we have 4 law subjects that we have to study and to score in this SEM. And time management is very important. For example, we can make a schedule, right? So at this hour we study contract law. After that we learn constitutional law. So I think that if we don't manage our time properly, it won't be good for us.
So in conclusion, what we have learned in contract law is that I can identify legal principles
And I can edit poster through tutorial.
To edit videos, teamwork.
Well, throughout the video, we know that the knowledge of the contract law not only enhance the legal awareness, but also help individuals to make informed decisions and also avoid potential dispute.
Therefore, understanding contract law is important for anyone who engage confidently and responsibly in modern society.